Tonight, we examine a case that once commanded national attention and then became part of British legal history. A single investigation, a single verdict, and a legacy that has endured for more than a century. The case of Matilda Hacker begins in Bloomsbury, London, in the autumn of 1877. Bloomsbury at that time was a district of substantial Georgian and early Victorian terraced housing, laid out around garden squares and occupied by a mixture of professional families, tradesmen and lodgers who rented rooms within larger houses maintained by a leaseholder. London itself, by the late 1870s, had grown into the largest city in the world, with a population exceeding 4 million people, and Bloomsbury sat close to several of the great railway termini that had reshaped the northern edge of the city over the preceding decades. Euston Station, opened decades earlier and expanded through the middle of the century, brought a constant movement of travellers, goods and new residents into the surrounding streets, and the area around Euston Square had, by this period, taken on a transient character. Houses that had once been occupied by single families were increasingly subdivided into lodgings, let room by room to individuals and small households who might remain for months or, in some cases, for only a matter of weeks. Euston Square itself, a residential square typical of the period, was lined with terraced townhouses of 4 and 5 stories, each with a basement level given over to kitchens, storage and coal cellars, accessed both from within the house and from a small area at street level. The coal cellar was an ordinary feature of such houses, used for the storage of household fuel and swept out periodically by servants or by members of the household as part of routine domestic maintenance. It was in one such house, at number 4 Euston Square, that the household of Severin Bastendorf resided. Bastendorf was a bamboo furniture manufacturer by trade, an occupation reflective of a minor but genuine Victorian industry in imported and imitation furnishings, and he held the lease on the property, sharing it with his family, at least one domestic servant, and at various times lodgers who took rooms within the house. It was into this household, in the autumn of 1877, that a woman calling herself Miss Uish took a room as a lodger. The name was not her own. The woman who presented herself under that name, at 4 Euston Square, was in fact Matilda Hacker, a woman of independent property who had spent recent years moving between a series of London addresses under a series of assumed names, apparently in order to remain ahead of creditors and local rate collectors. The household at number 4 Euston Square had no reason to suspect that the woman calling herself Miss Uish was anyone other than she claimed to be, and she was received and lodged as any other tenant of the house would have been received and lodged. What followed her arrival, and what would not come to light for a further 18 months, would place this ordinary Bloomsbury lodging house at the centre of one of the most closely examined criminal investigations of its decade. Matilda Hacker was born in 1811 in Canterbury, Kent. The surviving record of her early life is limited, and the documentary trail concerning her family origins, her parents, and the precise source of her later financial independence does not survive in sufficient detail to establish with certainty. What can be stated is that she was a woman of independent means throughout her adult life, deriving income from property rather than from employment, and that she remained unmarried. No record of siblings, of a household in Canterbury beyond her birth there, or of a occupation prior to her years of independent means, has been established. By the time she appears clearly in the documentary record, in the London of the 1870s, she was already a woman of some means who lived without a fixed household of her own family around her. She was documented by those who encountered her in this later period as a woman given to eccentric habits, including a manner of dress that was noted as more suited to a woman considerably younger than her actual years, and a marked wariness that led her to believe, at various points, that she was being watched or pursued. This wariness is recorded as having translated into a consistent pattern of behaviour. Rather than remaining at a single address under her own name, Hacker moved repeatedly between London lodgings, adopting a series of assumed names as she went. At earlier addresses, she is recorded as having used the names Miss Sycamore and Miss Bell. At 4 Euston Square, she presented herself as Miss Uish. This pattern of movement and assumed identity has been read by those who later examined the case as a practical strategy adopted by a woman seeking to avoid the attention of creditors and of the local officials responsible for collecting property rates, rather than as a symptom of disordered thinking alone, though the surviving record does not permit a definitive judgment on her reasons. What is established is that the pattern was persistent, spanning multiple addresses over a period of years, and that it left her, by the time she arrived at Euston Square, without a settled circle of family or acquaintance who might have noticed her absence had she failed to appear at an expected time. She had, by all available indication, no spouse, no children, and no immediate family resident in London who maintained regular contact with her. This absence of close family connection would prove to be a significant factor in the length of time that would pass before her disappearance was noted by anyone outside the household in which she lodged. This story begins in an ordinary Bloomsbury household. Much like countless others, Matilda Hacker's residence at 4 Euston Square was, in the context of her recent years, unremarkable. She had taken rooms in a succession of London houses before arriving there, and there was nothing in the manner of her arrival to distinguish it from any previous move. She paid for her lodging, kept largely to herself within the house, and was known to the Bastendorf household and its other occupants only under the name she had given, Miss Uish. The household at number 4 Euston Square, in addition to Severin Bastendorf himself, included his family and a domestic servant named Hannah Dobbs, who lived within the house in the ordinary manner of a resident servant of the period. Dobbs was employed to perform the domestic duties expected of a servant in a household of this kind, including, as later testimony would establish, some responsibility for the maintenance of the lower portions of the house, among them the coal cellar. The relationship between Dobbs and Bastendorf would later become a matter of considerable significance to the investigation, as evidence presented at trial indicated that the two had maintained a relationship beyond that of employer and servant, a matter that Bastendorf would subsequently deny under oath. At the time of Hacker's residence in the house, however, this relationship was not a matter of public knowledge, and the household continued in its ordinary daily routine. Hacker was last seen at the house in October of 1877. The precise circumstances of her final days at the address, whether she gave any indication of an intention to leave, whether she was seen departing the house, or whether she simply ceased to appear within it, are not established with certainty in the surviving record. What is clear is that after October of 1877, Matilda Hacker was not seen again by those who had known her under the name Miss Uish, and that no report of her absence was made to the police at that time, or in the months that immediately followed. The absence of any such report is directly attributable to the circumstances of Hacker's life in the years preceding her disappearance. A woman who moved frequently between addresses, who used a different assumed name at each, and who maintained no regular contact with family members who might have expected to hear from her, was a woman whose disappearance from any single address would not, in the ordinary course of events, be remarked upon. Landlords and fellow lodgers of the period were accustomed to a degree of transience among London's lodging population, particularly in a district such as Bloomsbury, where rooms were let and vacated with some regularity. A lodger who failed to reappear, whose rent had presumably been settled, or whose belongings had presumably been dealt with in some fashion, was not, in itself, cause for alarm or for police involvement. It was this ordinary tolerance for transience, combined with the particular circumstances of Hacker's isolation from family and her habit of moving under assumed names, that permitted her absence to pass without formal notice for a period that would ultimately extend to approximately 18 months. During that period, the household at 4 Euston Square continued to occupy the house in the ordinary course of its affairs. Bastendorf continued his trade as a bamboo furniture manufacturer. Hannah Dobbs continued in her position as domestic servant. The coal cellar of the house in which Matilda Hacker's body lay concealed throughout this period continued to be used for its ordinary domestic purpose, the storage and periodic removal of coal for household fuel, without any indication reaching the household's occupants or any visitor to the house that the cellar contained anything beyond its intended contents. The eventual discovery, when it came, would arise not from any external investigation, but from the routine performance of an ordinary household task. The discovery of Matilda Hacker's body took place on the 9th of May, 1879. On that date, a member of the Euston Square household was sent down to the coal cellar to carry out the ordinary task of clearing and sweeping the space, a chore that formed part of the routine domestic maintenance of the house. In the course of that work, the remains of a body were uncovered beneath the accumulated coal and debris of the cellar floor. A length of rope was found about the neck of the deceased, a detail consistent with death by strangulation. The condition of the remains, after a concealment that had by then extended to approximately 18 months, was such that the household member who made the discovery could not identify the body, and the matter was reported at once to the police. The discovery brought to an abrupt end a period of 18 months, during which the household at 4 Euston Square had continued its daily routine directly above the concealed remains, and it set in motion an investigation that would occupy the attention of the newly formed Criminal Investigation Department, the detective branch of the Metropolitan Police, that had itself been established only the previous year, in 1878. The case would come to be regarded within the department as one of its earliest significant tests. A murder investigation of considerable public interest falling to a body of professional detectives that was at the time barely more than a year into its existence. The investigation was formally opened within hours of the discovery being reported. Officers were dispatched to 4 Euston Square to secure the scene, and the coal cellar itself was examined in detail by those charged with the inquiry. The case was assigned to Inspector Charles Hagan of the Criminal Investigation Department, who took charge of the inquiry from its earliest stages. Given the length of time that had elapsed since the presumed date of death, and the condition in which the remains were found, one of the first tasks facing the investigation was the establishment of identity. This was not achieved through any immediate or obvious means, since the woman who had lodged at the house, under the name Miss Uish, had left behind her no family connection through which she might readily be traced. Investigators were obliged to work backward from the circumstances of her tenancy, examining what possessions and papers she had left in the house, and tracing her movements and associations during the period of her residence there. This process of establishing identity occupied a considerable portion of the early investigation, and it was only through careful inquiry into her prior addresses and the names under which she had been known that the identity of Matilda Hacker was eventually confirmed, and her connection to a woman of independent property, previously resident under other names at other London addresses, was established. Once the identity of the deceased had been confirmed, the investigation turned its attention to the household in which she had lodged and to the period following her disappearance in October of 1877. Officers took statements from members of the Bastendorf household, from Severin Bastendorf himself, and from the domestic servant Hannah Dobbs, who had lived within the house throughout the period in question and who had been responsible, among her other duties, for aspects of the household's lower rooms, including the cellar in which the body had lain concealed. In the course of these inquiries, investigators established that in the period following Hacker's disappearance, certain items of property belonging to her had come into the possession of others outside the household, having been pawned at establishments in London. The tracing of these pawned items to Hannah Dobbs formed the single, most concrete evidentiary thread developed during the investigation, and it was this discovery that led directly to her being identified as a suspect in the case. Investigators established the dates and locations at which the items had been pawned, and cross-referenced these transactions against the known movements of Dobbs during the period following Hacker's last appearance at the house. This work required the examination of pawnbrokers' records across multiple premises and the corroboration of individual pawnbrokers' recollections of the woman who had brought the items to them. Parallel to this line of inquiry, investigators examined the relationship between Hannah Dobbs and Severin Bastendorf, which had, by this stage of the investigation, come to their attention as a matter separate from, though related to, the central question of the murder itself. Bastendorf, when questioned, denied under oath that his relationship with Dobbs extended beyond that of an employer to a domestic servant. Investigators, however, continued to gather statements and evidence bearing on the true nature of that relationship, evidence which would later be presented at trial and which would ultimately form the basis of a separate charge against Bastendorf. The investigation into the household therefore proceeded along two connected tracks, one directed at establishing responsibility for the death of Matilda Hacker, and the other at establishing the truth of the relationship between the two principal occupants of the house during the period in which her body had lain concealed beneath it. Statements were taken from neighbours and from tradespeople who had had dealings with the household during the relevant period, in an effort to establish a fuller picture of the comings and goings at 4 Euston Square across the 18 months in question. This process of gathering corroborating testimony extended over a period of weeks following the discovery, as investigators worked to assemble a case suitable for presentation before a court. A post-mortem examination of the remains was conducted following the discovery, and it was this examination that established the presence of the rope about the neck of the deceased as consistent with death by strangulation. The examining physician's findings were limited by the extended period of concealment, which had left the remains in a condition that made a number of ordinary post-mortem determinations difficult to establish with precision. The length of time that passed since death, a period that could not be fixed with certainty, given the conditions of concealment within the cellar, meant that investigators and medical examiners alike were unable to determine an exact date of death. The last confirmed sighting of Matilda Hacker at the house in October of 1877 remained the earliest point from which the period of her death could be reckoned, though some among those who reviewed the case in later years suggested that the death may not have occurred until as late as the autumn of 1878. The surviving record does not permit this question to be resolved with certainty, and the exact date on which Matilda Hacker met her death has never been established beyond dispute. What the medical examination did establish, and what was presented as settled fact before the inquest and later the court, was that the rope found about her neck was consistent with strangulation as the cause of death, and that no other explanation for the presence of the rope, or for the concealment of the body beneath the house, was consistent with an accidental or natural death. An inquest was convened following the post-mortem examination, in the ordinary course required by law whenever a death occurred under circumstances suggesting other than natural causes. The inquest heard evidence concerning the discovery of the body, the medical findings as to the likely cause of death, and the circumstances of Hacker's tenancy at 4 Euston Square. Witnesses connected with the household were called to give evidence as to the period of her residence and her disappearance in October of 1877. The proceedings of the inquest, in combination with the results of the ongoing police investigation, led to the case being committed for trial, with Hannah Dobbs named as the person to answer the charge of murder. The committal proceedings that followed the inquest examined the evidence gathered by investigators regarding the pawned property and the movements of Dobbs during the period following Hacker's disappearance, and on the strength of this evidence, the magistrate ordered that she be sent forward to stand trial at the Old Bailey. The case against her, as it stood at the close of these preliminary proceedings, rested substantially on her position within the household during the period in which the body had lain concealed, and on the connection established between her and property that had belonged to the deceased. The trial of Hannah Dobbs, on the charge of murdering Matilda Hacker, opened at the Old Bailey in the summer of 1879. The proceedings drew considerable public attention, reflecting both the unusual nature of the case, in which a body had lain undiscovered beneath an occupied house for a year and a half, and the early prominence of the Criminal Investigation Department's involvement in bringing the matter to trial. The prosecution presented its case around the central evidentiary thread developed during the investigation, namely the discovery that items of property belonging to Matilda Hacker had been pawned by Dobbs following the older woman's disappearance from the house. Pawnbrokers were called to give evidence identifying Dobbs as the individual who had brought the items to their premises, and investigators gave evidence as to the dates on which these transactions had occurred relative to Hacker's last confirmed appearance at the house. The prosecution argued that Dobbs's possession and disposal of this property, combined with her position within the household and her access to the lower rooms of the house, including the coal cellar, was sufficient to establish her responsibility for the death. The defence case challenged this evidence on several grounds, arguing that possession of pawned property, while suspicious, did not in itself establish that Dobbs had caused the death of Matilda Hacker, and that the prosecution had not produced direct evidence connecting her to the act of strangulation or to the concealment of the body in the cellar. Defence counsel pressed upon the jury the absence of any witness to the killing itself, the absence of a confirmed date of death against which Dobbs's movements might be tested, and the fact that other members of the household, including Severin Bastendorf, had equal access to the cellar in which the body was found. The defence argued further that the circumstances of the case, resting as they did on inference from the disposal of property rather than on direct evidence of the act itself, fell short of the standard required to convict on a charge of murder. Over the course of the trial, both sides called a succession of witnesses connected to the household, to the pawnbroking establishments, and to the investigation itself, and the proceedings extended across multiple days as the evidence was examined and tested before the court. The jury retired to consider its verdict after hearing the full body of evidence presented by both prosecution and defence over the course of the trial. Upon its return, the jury delivered a verdict of not guilty, finding that the evidence presented had not established Hannah Dobbs's guilt to the standard required in a capital case. Hannah Dobbs was acquitted of the murder of Matilda Hacker, and she left the court without further charge in connection with the death. No other individual was subsequently brought to trial on the charge of murder in relation to the case, and the question of who had caused the death of Matilda Hacker and concealed her body beneath the coal cellar of 4 Euston Square was not resolved by the proceedings at the Old Bailey or by any inquiry that followed them. Attention, in the aftermath of the trial, turned to the matter that had arisen alongside the murder investigation concerning the true nature of the relationship between Severin Bastendorf and Hannah Dobbs during the period in which she had resided in his household as a domestic servant. The charge originally contemplated against Bastendorf in connection with the death of Matilda Hacker was not pursued to trial, and he was not tried on any charge relating to the murder itself. He was, however, brought before the court on a separate charge of perjury, arising from his sworn denial that his relationship with Dobbs had extended beyond that of employer and servant. Evidence was presented establishing that this denial had been false, and that the relationship between the two had in fact been of an intimate character, contrary to what Bastendorf had stated under oath during the course of the investigation. The court found the charge of perjury proven, and Severin Bastendorf was convicted on this count. He was sentenced to a term of 12 months' imprisonment for the offence. This sentence was carried out in the ordinary course, and no further legal proceedings against him in connection with the case are recorded in the surviving documentary account. The murder of Matilda Hacker itself remained, at the conclusion of these proceedings, formally unresolved. with no individual convicted of causing her death. The public reaction to the case, both during the trial and in the months that followed, was substantial, reflecting the unusual circumstances of a body concealed for 18 months beneath an occupied house in a respectable London square, and the acquittal of the principal suspect brought before the court. Press coverage of the trial had been extensive throughout its course, and the case continued to attract comment in the London papers following the verdict, particularly as the perjury conviction against Bastendorf became known. Within the district itself, the case left a mark that extended beyond the courtroom and into the physical fabric of the neighbourhood. Residents and local authorities in the vicinity of Euston Square had, by the autumn following the trial, come to associate the name of the square directly with the notoriety of the case, a connection that a number of residents evidently found undesirable given the square's standing as a respectable residential address. This local concern translated into a formal petition, brought before the vestry of St Pancras, the parish authority with responsibility for such matters, requesting that the name of the affected side of the square be changed in order to distance the address from its association with the murder. The petition from the vestry of St Pancras was formally received by the Metropolitan Board of Works, the body responsible at that time for matters of London street naming and civic infrastructure, on the 25th of September, 1879. The board considered the request over the following months, weighing the petition against the ordinary procedures governing changes to established street names within the metropolis. On the 5th of December, 1879, the Metropolitan Board of Works resolved to approve the change, and the south side of Euston Square, the side on which number 4 stood, and in which the body of Matilda Hacker had lain concealed, was renamed Ensley Gardens. The new name was adopted formally from that date forward, and the address at which the case had unfolded ceased from that point to bear the name under which it had become known throughout the trial and the press coverage surrounding it. The name Ensley Gardens has remained in use for that stretch of the street from 1879 to the present day, making the renaming one of the most concrete and lasting physical traces of the case within the fabric of the city itself. Where a visitor to the district today might look for Euston Square as it existed in the 1870s, only the northern portion of the original square retains that name, the southern side having carried a different designation for close to a century and a half. The case of Matilda Hacker has continued to attract attention in the decades since the trial, sustained in part by the unresolved question of responsibility for her death, and in part by the unusual circumstances of the 18-month concealment within an occupied household. Sinclair Mackay's account of the case, published in 2022 under the title Murder at Number 4 Euston Square, brought the case to a wide modern readership, drawing on the surviving trial records, press coverage, and biographical detail concerning the principal figures involved. Adrian Holden has separately produced a detailed study of the evidence assembled during the original investigation, examining the case from the perspective of the material gathered by Inspector Hagan and his colleagues in the Criminal Investigation Department. David R. Lewis has contributed a biographical account focused on Matilda Hacker's origins in Canterbury and her early life prior to her years of residence under assumed names in London, work carried out in connection with the Canterbury Archaeology Society's interest in local historical figures. Together, these accounts have kept the case before the public over more than a century since the original trial, each drawing on a different aspect of the surviving record to reconstruct the events at 4 Euston Square and their aftermath. The historical significance of the case rests substantially on its position within the early institutional history of professional detective policing in London. The Criminal Investigation Department, established in 1878, was barely a year into its existence when Inspector Hagan was assigned to the investigation into Matilda Hacker's death, and the case stands as one of the department's earliest high-profile undertakings, conducted at a moment when the methods and public standing of professional detective work in London was still very much in the process of formation. The investigation required detectives to establish the identity of a victim who had deliberately obscured her own name and movements, to trace pawned property across multiple London establishments, and to assemble a case suitable for presentation at the Old Bailey, all within the working practices of a branch of the police force still finding its footing. The eventual acquittal of Hannah Dobbs, and the failure to bring any other individual to trial for the murder itself, left the case as one of the notable unsolved killings associated with the department's formative years, a case in which the machinery of investigation and prosecution had been fully engaged without producing a conviction for the central offence. The broader social conditions reflected in the case were characteristic of late Victorian Bloomsbury, a district in which multi-occupancy lodging houses brought together leaseholders, families, servants, and lodgers within a single dwelling, often with limited knowledge of one another's pasts or circumstances. Matilda Hacker's own pattern of life, moving between addresses under a succession of assumed names in order to remain ahead of creditors and rate collectors, was not unique to her individually, but reflected a documented strategy available to women of independent means who lacked the protection of a settled family household. Such women could maintain a considerable degree of anonymity within a city the size of London, taking rooms in houses where a leaseholder's primary concern was the reliable payment of rent rather than the verification of a lodger's true identity or family background. It was precisely this anonymity, sustainable across multiple addresses and multiple years, that allowed Matilda Hacker's death to go unremarked for so long, and that left investigators, once the body was discovered, with the initial task of determining not only how she had died, but who, in fact, she had been. The system of property rates that formed the backdrop to Matilda Hacker's evasive movements between addresses was itself a routine feature of the London in which she lived out her final years. Rates were levied on the occupiers of dwellings by the local parish authorities, collected at regular intervals by officials who visited households directly, and a lodger who wished to avoid the notice of such collectors needed only to move before the collector's rounds caught up with her settled name and address. A woman such as Hacker, drawing income from property she held elsewhere and requiring no employer's reference to secure a room, could present herself under a new name at each fresh address, pay her rent in the ordinary way, and excite no particular curiosity so long as her conduct within the household gave no cause for complaint. Landladies and leaseholders of the period, Bastendorf among them, kept no systematic record of a lodger's origins beyond what was needed to secure the weekly or monthly rent, and it was this simple, transactional character of the London lodging market that made the strategy available to a woman in Hacker's position. The pawnbroking system that later proved central to the case against Hannah Dobbs operated on a similarly transactional basis. Pawnbrokers of the period were required to record the details of certain transactions and to retain items for a set period before offering them for resale, a practice that gave investigators a documentary trail to follow once suspicion had fallen upon Dobbs, but that had not at the time the items were pawned drawn any particular scrutiny to the woman who brought them in. It was only in retrospect, once the connection between the pawned items and the missing lodger at Euston Square had been established, that the individual transactions took on their significance as evidence, each one a small dated record of an object passing from Hacker's possession into another's hands during the very months in which her body lay beneath the house. The house at number 4 Euston Square, in common with its neighbours along that side of the square, had been built in the earlier decades of the century to a standard terraced pattern, 4 stories above a basement level, with a narrow flight of steps leading down from the street to the basement area and a separate internal staircase connecting the basement to the floors above. The coal cellar itself lay beneath the pavement at the front of the house, reached both by an internal door from the basement kitchen and by a hinged iron coal hole set into the pavement above, through which coal deliveries were tipped directly down a chute without the coalman needing to enter the house at all. This was the ordinary arrangement across Bloomsbury and much of London in this period, a practical accommodation to the demands of a city that burned coal for heating and cooking in nearly every household, and it meant that the cellar in which Matilda Hacker's body came to rest was a space visited only intermittently, chiefly when coal was delivered or when supplies were fetched up for use, rather than a room in regular daily occupation by any member of the household. Severin Bastendorf conducted his trade as a manufacturer of bamboo furniture from premises connected to the house, working in a style of furnishing that had grown fashionable in British households through the middle decades of the century, as imported bamboo and reproductions in the same material found favour for occasional tables, plant stands, and light chairs suited to parlours and drawing rooms. The trade required storage for raw cane and finished stock, and it is consistent with the working arrangements of small manufacturers of the period that such storage, along with the ordinary domestic coal supply, would have been kept in the cellar spaces beneath the house, spaces that saw use but not constant attention from the household above. The press coverage that followed the discovery of the body and the subsequent trial was extensive by the standards of London's newspaper market in 1879, a period in which numerous daily and weekly papers competed for readers with detailed accounts of criminal proceedings, court testimony reproduced at length, and illustrations depicting scenes connected to notable cases. Reports of the discovery at Euston Square appeared across multiple London papers in the days following the 9th of May, and coverage of the trial itself, once it opened at the Old Bailey, ran across successive issues as the proceedings unfolded over several days. This sustained coverage is itself part of what carried the case beyond the immediate neighbourhood and into wider public awareness, feeding the concern among residents of the square that led, within months of the trial's conclusion, to the petition for a change of name. The correspondence submitted to the vestry of St. Pancras in support of that petition drew directly on the language of the press coverage, citing the association between the name Euston Square and the reporting of the case as a source of the difficulty the residents wished to address. This connection between newspaper reporting and the eventual physical alteration of the street itself illustrates the degree to which the case had penetrated public consciousness within the space of a single year, from an ordinary domestic tragedy investigated behind closed doors to a matter of sufficient civic concern that a body such as the Metropolitan Board of Works was called upon to formally amend the map of the city. The task of tracing Matilda Hacker's identity backward through her prior addresses required investigators to work systematically through each of the assumed names under which she had been known before her final tenancy at Euston Square. Officers visited the former lodgings associated with the names Miss Sycamore and Miss Bell, interviewing the landladies and fellow lodgers who had known her under those identities, in an effort to establish a continuous chain connecting the woman found in the cellar to a single, verifiable person, rather than to the fragmented series of names under which she had chosen to live. Each address visited yielded a partial description, a recollection of manner or appearance, a note of the dates during which she had resided there, and it was only by assembling these separate fragments that investigators arrived at a coherent account of her movements across the several years preceding her arrival at 4 Euston Square. Former landladies recalled a woman who kept largely to her rooms, who paid her rent with regularity, and who gave little information about her circumstances beyond what was strictly necessary to secure a tenancy. This pattern, repeated at address after address, corroborated the picture that would later be presented of a woman deliberately maintaining her own obscurity, moving before questions could accumulate around her, and leaving behind at each address only the thin trace of a name that was not her own. The eventual identification of these separate tenancies as belonging to a single individual, Matilda Hacker of Canterbury, was achieved through the patient cross-referencing of these accounts against documents and personal items recovered from her room at Euston Square, items that connected the woman known there as Miss Uish to earlier transactions and correspondence conducted under her true name. The trial at the Old Bailey proceeded according to the established procedure of that court, with the accused brought into the dock to hear the charge read, and the business of empanelling a jury conducted before the opening statements of counsel were heard. The courtroom itself, in common with the practice of the period, accommodated a public gallery in addition to the jury box, the bench and the areas reserved for counsel and for the press, and the unusual interest attaching to the Euston Square case ensured that both the gallery and the reporters' benches were fully occupied throughout the days on which the trial was heard. Reporters present in court transmitted accounts of the day's proceedings to their respective papers each evening, accounts that were set in type and available to readers across London by the following morning, a process that allowed public interest in the case to be sustained and renewed with each fresh day of testimony. Witnesses were called forward in turn to the witness box positioned before the bench, sworn according to the customary oath, and examined first by counsel for the prosecution, and then cross-examined by counsel for the defence, a sequence repeated across the numerous witnesses drawn from the household, from the pawnbroking establishments, and from the ranks of the investigating officers themselves. The formality of this procedure, the reading of testimony, the entering of exhibits including the recovered items of Hacker's property, and the careful pacing of examination and cross-examination extended the trial across several sitting days before the case was considered sufficiently presented for the jury to retire. The charge of perjury brought against Severin Bastendorf was tried as a separate matter from the murder proceedings, following the acquittal of Hannah Dobbs, and it addressed specifically his sworn testimony given during the earlier stages of the investigation, in which he had denied that his association with Dobbs extended beyond the ordinary relationship of an employer to a domestic servant. The prosecution in this second trial called witnesses drawn from within the household and from among those acquainted with its members, whose testimony was directed at establishing that the relationship between Bastendorf and Dobbs had in fact been of an intimate nature, sustained over a period of time, and known in general terms to others connected with the household, even if not openly acknowledged. Evidence was presented demonstrating the falsity of his earlier sworn statement, evidence sufficient for the court to find the charge proven. The proceeding was shorter than the murder trial that had preceded it, concerned as it was with a single, narrower question, namely whether Bastendorf had lied under oath, rather than with the broader question of responsibility for a death. Upon the charge being found proven, the court proceeded to sentencing, and Bastendorf was committed to a term of 12 months' imprisonment. The sentence reflected the gravity with which the courts of the period treated the offence of perjury, an offence understood to strike at the integrity of sworn testimony, and by extension at the reliability of the judicial process itself, particularly in a case that had already drawn such extensive public attention. No appeal against this conviction is recorded in the surviving account of the case, and Bastendorf served the sentence imposed upon him before disappearing from the documentary record insofar as this case is concerned. Public opinion in the aftermath of the two trials was reported as divided on the question of Hannah Dobbs's innocence, a division reflected in the correspondence columns of several London papers in the weeks following the murder trial's conclusion. Some correspondents expressed satisfaction that the jury had declined to convict on evidence they regarded as circumstantial, resting, as it did, on the disposal of pawned property rather than on direct proof connecting Dobbs to the act of strangulation itself. Others expressed the view that the acquittal had left a case of evident gravity without a resolution that the public could regard as just, and pointed to her position within the household, her access to the cellar, and her established possession of the deceased's property as circumstances that, taken together, seemed to them to point toward her involvement, whatever the jury's formal finding. This division of opinion was not resolved by any subsequent development, and the case passed into the historical record, still carrying, alongside its formal verdict of acquittal, this undercurrent of public uncertainty as to where responsibility for the death had truly lain. The 18 months during which Matilda Hacker's body lay beneath the house at 4 Euston Square encompassed the entire ordinary rhythm of a Victorian household's year, a span across which the Bastendorf family marked the passage of 2 winters, the delivery and consumption of successive loads of coal drawn from the very cellar in which the concealment lay, and the daily comings and goings of a working household engaged in trade, in domestic service, and in the raising of children within its walls. The servant tasked in May of 1879 with clearing and sweeping the cellar in preparation for a fresh delivery of coal approached the task as one among the countless similar tasks performed in that space over the preceding year and a half, with no reason to anticipate anything beyond the ordinary accumulation of dust, small debris, and the residue of fuel long since burned in the grates above. The discovery that interrupted this routine task altered, in a single moment, the character of a space that had been visited repeatedly, without incident, throughout the entire period of concealment, and it was this abrupt disruption of an otherwise unremarkable domestic chore that brought the case, at last, to the attention of the authorities, 18 months after the woman known in that house as Miss Uish had ceased to be seen within it. The confirmation of Matilda Hacker's identity carried consequences beyond the criminal investigation itself, since a woman of independent property, who died without a will properly accounting for her affairs, left behind questions of inheritance that required separate attention from the ordinary processes of probate. Once her true identity had been established and reported in the press, distant relatives connected to her Canterbury origins came forward to make inquiries regarding her estate, a estate that consisted principally of property holdings from which she had drawn her income during the years of her residence under assumed names in London. The administration of this estate proceeded through the probate courts in the ordinary manner reserved for cases in which a person of means died without close family resident with her at the time of death, a process complicated in this instance by the 18 months during which her whereabouts and indeed her survival had remained entirely unknown even to those relatives who might otherwise have expected to hear from her. The Canterbury connection, established through the same lines of inquiry that had confirmed her identity for the purposes of the criminal investigation, provided the necessary basis for relatives to substantiate their claims upon the property she left behind, and the estate was in due course settled according to the ordinary rules of inheritance applicable to a woman who had died without issue and without a surviving spouse. The news of Matilda Hacker's death, once her identity became known, was received in Canterbury with the particular attention that a county town of the period afforded to the fate of one of its own, however long she had lived apart from it. She had departed Canterbury as a young woman and had spent the greater part of her adult life in London, latterly under names that severed even the loose thread of local memory that might otherwise have connected her continuing existence to her place of birth. The revelation that a woman found murdered and concealed beneath a fashionable London square was in fact a native of Canterbury, gave the case a local dimension in Kent that it would not otherwise have possessed, and it is this connection that later drew the attention of local historians and archivists to her early biography, work that would only be undertaken in a systematic way many decades after the events themselves, once the case had passed fully into historical rather than immediate memory. The gap between her departure from Canterbury in her youth and her reappearance in the historical record as the victim of the Euston Square case spans several decades, a gap across which the documentary trail of her life, prior to her years of assumed names in London, remains thin, consisting chiefly of the fact of her birth in 1811 and the general understanding that she possessed independent means. Without the fuller record of family circumstance or early occupation that exists for other figures of the period whose lives were more continuously documented. This is an unsolved case, so Category E fits best. The investigation was formally closed. No one was ever convicted of the murder. The case remains open. The record remains incomplete. The investigation into the first case had, by its conclusion, produced a verdict that history preserved and continued to examine. That is where the record of the first case ends. We turn now to a second case, quieter than the first and considerably less remembered, one that unfolded in a different corner of London, in a different decade, and turned upon a question that no inquest was ever able to answer. The case of Sarah Squires and her daughter Christiana Squires begins in Hoxton, in the east of London, in the summer of 1872. Sarah Squires was a widow who had continued to run the family trade after the death of her husband, and Christiana Squires, her unmarried daughter, lived and worked alongside her. In the early 1870s, Hoxton was a densely built district of the East End, positioned north of the City of London and east of the more fashionable streets of Islington. It formed part of the parish of Shoreditch and lay within the wider expanse of working-class London that stretched from the docks in the south to the market gardens and rail yards in the north. The population of the district was composed largely of tradesmen, artisans, small manufacturers, and shopkeepers, many of whom lived above or behind their own premises, so that the boundary between household and business was, for families such as the Squires, a thin one. The streets of Hoxton in 1872 were lined with narrow-fronted shops and workshops, many of them specialising in furniture making, cabinet work, and the printing and picture trades for which the district had become known. Hyde Road, where the Squires family kept their shop, ran through the heart of this commercial quarter, lined with premises that combined retail frontage with living quarters above or behind the counter. The wholesale picture and print trade in which Sarah Squires dealt supplied smaller retailers and street vendors with engravings, prints and framed pictures intended for resale, a business that depended on steady foot traffic and a reliable set of trade customers rather than passing casual buyers alone. London, in 1872, was a city still absorbing the rapid growth of the preceding decades, its population having expanded considerably since the middle of the century, as migration from the countryside and from Ireland continued to swell the working districts of the East End. Hoxton itself had grown crowded, its terraces subdivided, and its courts and yards filled with a density of habitation that placed considerable strain on sanitation, water supply, and public order. Yet it remained in the main a respectable working quarter, distinct from the more notorious rookeries further east, home to families who worked steadily at trades passed down through generations. The Squire's shop at number 46 Hyde Road stood among these premises, its front given over to the display and sale of prints and pictures, its interior stocked with the wholesale goods that formed the basis of the family's livelihood. It was, by the standards of the district, an ordinary business, conducted openly and visibly from a shop that fronted directly onto a public thoroughfare, its counter and stock visible to any customer who stepped through the door. It was within this setting, ordinary in every visible respect, that the events of the 10th of July 1872 took place. Sarah Squires had been widowed some years before the events described here, and in the period following her husband's death, she had continued the family business rather than relinquishing it, a choice that placed her among a smaller number of Victorian women who maintained independent trade, standing in their own right. The precise date of her husband's death, his name, and the circumstances under which the business passed into her sole management are not reliably established in the surviving record, and no attempt is made here to supply detail beyond what the documentation allows. What is established is that by 1872, Sarah Squires operated the wholesale picture and print business from the Hyde Road premises as its proprietor, a position that required her to manage stock, credit, and trade relationships with the retailers and hawkers who purchased from her. Her age at the time of her death is not established with certainty. The card summary associated with this case gives her age as 77, while contemporary newspaper reporting from the period, as preserved in later archival transcription, gives her age as 73. The discrepancy between these figures cannot be resolved from the material available, and this account treats her age only in approximate terms, as a woman in her 70s, without asserting either figure as settled fact. Christiana Squires, her daughter, remained unmarried and lived with her mother at the Hyde Road premises, where she appears to have worked alongside her in the running of the shop. As with her mother's age, Christiana's age at the time of her death is not established with certainty. The card summary gives her age as 36, while the contemporary press account gives her age as approximately 30. This account likewise treats her age only in approximate terms, as a woman in her 30s. Nothing further is reliably documented of her personal history, her education, or her earlier life prior to the events of July 1872, and no invented detail is offered to fill that gap. The relationship between mother and daughter, so far as the surviving record permits any statement at all, appears to have been one of shared domestic and commercial life, the two women residing together and conducting the business together, without any indication in the available sources of discord or estrangement between them. Trade directories and rate records of the period, of the kind that might, in principle, establish the precise length of the family's tenancy at Hyde Road or the scale of their stock, have not survived in a form accessible to this account, and so the picture that can be offered of their daily circumstances remains limited to what the press coverage of the crime itself preserved. It should be noted, for the sake of clarity, that Christiana Squires of this case is not to be confused with Christiana Edmonds, a defendant tried at the Old Bailey in January of 1872 on charges connected with poisoning. The two women shared a given name and were contemporaries within the same calendar year, but the resemblance ends there. Christiana Edmonds was a defendant in a criminal trial. Christiana Squires was a victim of an unsolved crime committed some 6 months later in a different part of London under entirely different circumstances. The two cases are unrelated, and no connection between them is asserted or implied. The business the two women conducted together depended, as wholesale trades of this kind generally did, on a routine of opening the shop each morning, receiving deliveries of stock from suppliers, and serving the retailers and street sellers who came to purchase prints and pictures for resale elsewhere. Such a routine would have brought a steady, if modest, stream of visitors through the shop on any ordinary weekday, familiar faces for the most part, tradesmen and hawkers known to the family through repeated dealings. There is no indication in the surviving record that the shop was unusually prosperous or that its stock was of particularly high value, nor is there any indication of the opposite, that the business was failing or in difficulty. It appears, so far as can be established, to have been an ordinary concern of its kind, conducted without evident distinction in either direction. In the days and weeks preceding the 10th of July 1872, no disturbance, dispute, or threat involving either Sarah or Christiana Squires is recorded in the sources available for this account. There is no mention of a known enemy, a prior confrontation, or any circumstance that might, with the benefit of hindsight, have been read as a warning of what was to follow. The absence of such a record does not establish that no such circumstance existed, only that none has survived in the documentation on which this account is based. What can be said is that the 10th of July began, so far as the record indicates, as an ordinary day in the life of the shop, one indistinguishable in its early hours from any other. The morning of Wednesday, the 10th of July, 1872, found the shop at 46 Hyde Road, open for business in the customary manner. Witnesses in the neighbouring premises and on the street later gave accounts placing one or both of the women within the shop during the mid-morning hours, between approximately 9 and 11 o'clock, engaged in what appeared to be the ordinary conduct of trade. These sightings, taken together, suggested a household proceeding through an unremarkable morning, with no visible sign of distress or disturbance communicated to those who passed by or looked in through the shop window. At some point during that morning, however, the routine of the shop was violently interrupted. The precise hour at which this occurred could not afterward be fixed with confidence, a difficulty that would come to trouble the subsequent investigation. One witness maintained that he had seen Sarah Squires standing in the doorway of the shop as late as 12:30 in the afternoon, a sighting that sat uneasily alongside the earlier accounts, placing the household's ordinary activity in the mid-morning hours. This account preserves the difficulty as it appears in the record. The precise time at which Sarah and Christiana Squires were attacked does not admit of certain determination, and no attempt is made here to resolve the contradiction by selecting one account over the other. What is established is that at some point in the daylight hours of the 10th of July, within the shop itself, both women suffered violence that was to prove fatal. The shop remained, to outward appearance, open for the remainder of the early afternoon, its door unlocked and its interior accessible to anyone who might step inside. No alarm was raised during this interval, and no passerby is recorded as having noticed anything amiss from the street, a detail that later commentators found remarkable given the character of the injuries that were eventually discovered. The commercial life of Hyde Road continued around the shop as it always did, tradesmen and residents passing along the pavement outside of premises within which, unknown to any of them, an extraordinary crime had already taken place. It was shortly after 1 o'clock in the afternoon that the ordinary rhythm of the street was broken. A boy entering the shop in the expectation of purchasing a newspaper, a transaction of the most unremarkable kind, found the interior in a state of disorder inconsistent with any ordinary explanation. Blood and hair were visible upon the counter and scattered among the stock of prints and pictures that filled the shop. The boy, upon making this discovery, raised an alarm that quickly drew the attention of neighbours and passers-by to the premises. What followed was the rapid assembly of a crowd outside the shop, as word of the discovery spread along Hyde Road and beyond, and the recognition, confirmed within a short time, that both Sarah Squires and her daughter Christiana had been killed within their own premises, in the middle of an ordinary business day, without any witness having observed the act itself. The boldness of the crime, committed as it was in an open shop fronting a public street, during hours when the district was fully awake to its ordinary commerce, was remarked upon at the time as an act rarely paralleled in the experience of those who reported and investigated it. Notification of the discovery reached the officers of the local division within a short time of the alarm being raised, and constables were dispatched to Hyde Road to secure the premises against the crowd that had by then gathered outside the shop. The investigation was formally opened that same afternoon, with officers entering the premises to examine the scene and to begin the process of establishing what had taken place within it. The disorder found among the stock, the disturbed state of the counter, and the general condition of the shop's interior were noted as part of this initial examination, and it was this disorder that gave rise to the earliest working theory considered by the investigating officers, namely that the crime had been committed in the course of a robbery, the intruder or intruders having been surprised at their work by one or both of the women. Officers proceeded to canvass the immediate vicinity of Hyde Road, calling at neighbouring shops and dwellings to ask whether any resident or tradesman had observed unusual activity about the squire's premises during the course of the morning. This canvass produced the conflicting accounts of timing already noted, with some witnesses placing the ordinary business of the shop, and by implication the presence of both women alive and unharmed within the mid-morning hours, while at least one witness insisted upon a sighting of Sarah Squires as late as 12:30. Officers recorded these statements as given without being able, on the basis of the canvas alone, to reconcile the discrepancy between them. The interior of the shop itself was searched with a view to establishing what, if anything, had been taken. The stock of prints and pictures was examined against what records of inventory could be assembled, though the wholesale nature of the trade, in which goods moved regularly in and out of the premises, made any precise accounting of loss difficult to establish with confidence. Officers noted the disturbed condition of drawers and fittings within the shop, consistent with an intruder having searched the premises for money or portable valuables, though no conclusive statement as to what, if anything, had actually been removed could be reached on the basis of the search alone. Inquiries were extended beyond the immediate neighbours to the trade contacts of the business, the retailers and hawkers who purchased stock from Sarah Squires in the ordinary course of her dealings, in an effort to determine whether any visitor to the shop that morning could be identified and accounted for. Officers sought to establish a list of persons who might reasonably have called at the premises during the hours in question, whether for legitimate trade purposes or otherwise, and to trace the movements of each such person through the remainder of the day. This process of elimination, standard to investigations of this kind, proceeded through the following days without producing a suspect whose presence at the shop during the critical hours could be firmly established. The crowd that had gathered outside the premises on the afternoon of the discovery was itself a source of some difficulty to the officers conducting the investigation, since the press of onlookers threatened to compromise the physical evidence of the scene before a full examination could be completed. Constables were posted at the door to control access to the shop, and the premises were held under police supervision in the days that followed while the examination continued. Members of the public who claimed to have information relevant to the case were directed to present themselves at the local police station, a standard procedure by which officers hoped to gather further witness testimony beyond that obtained in the initial canvass. Officers also gave attention to the question of access to the rear of the premises, examining whether an intruder might have entered or departed by a route other than the shop's street-facing door, given that no witness had reported observing any person entering or leaving the shop in an agitated or hurried manner during the relevant hours. This absence of any reported sighting of a fleeing or suspicious individual was itself treated by the investigating officers as a matter requiring explanation, and inquiries were made as to whether the rear of the building offered access to a yard, alley, or adjoining property through which a person might have come and gone unobserved. As the investigation proceeded through the days following the discovery, officers continued to take statements from residents of Hyde Road and the surrounding streets, seeking any recollection, however small, that might assist in narrowing the window during which the crime had occurred, or in identifying a person seen in the vicinity of the shop who could not otherwise be accounted for. No individual was brought forward by these inquiries as a credible suspect, and the investigation, notwithstanding the considerable effort expended upon it in the weeks immediately following the 10th of July, did not result in an arrest. A post-mortem examination was conducted following the discovery of the bodies, and it was through this examination that the cause of death was formally established for both Sarah Squires and her daughter. The injuries sustained by each woman were found to be severe and rapidly fatal, consistent with repeated blows delivered with a heavy implement. The examining physician's findings were sufficient to establish that both women had died as a result of blunt force trauma to the head, and it was this finding, together with the presence of blood and hair upon the counter and stock of the shop, that confirmed the location of the attack as the shop itself rather than any other part of the premises. The examination further indicated that the injuries suffered by both women were of a similar character, suggesting that both had been attacked in close succession rather than at any significant interval apart, though the post-mortem findings could not establish with precision the order in which the two women had been struck, nor could they resolve the broader question of the exact hour at which the attack had taken place. The severity of the injuries was such that death, in the assessment offered at the time would have followed quickly upon the blows delivered, though the examining physician's name and the full particulars of the report are not preserved in the sources available for this account. An inquest was convened before the coroner in the days following the discovery, as was the standard procedure for a violent death investigated within the Metropolitan District. The inquest heard testimony from those neighbours and witnesses who had already given statements to the investigating officers, including the conflicting accounts of the hour at which Sarah Squires had last been seen alive. The boy who had discovered the scene was called to describe the condition in which he had found the shop, and the post-mortem findings were presented to establish the cause of death for both women. The inquest jury, having heard this testimony, was not in a position to return a verdict naming any individual as responsible for the deaths, no suspect having been identified by the investigation up to that point. The proceedings concluded with a finding consistent with willful murder committed by a person or persons unknown, a verdict that left the formal question of responsibility unresolved, while confirming, for the purposes of the official record, that both women had died as the result of criminal violence rather than accident or misadventure. The precise wording of the coroner's summation and the full particulars of the jury's finding are not preserved in the sources available for this account, though the substance of an open verdict, naming no defendant, is consistent across the record that does survive. No trial followed the inquest's open verdict, since no defendant had been identified or charged in connection with the deaths. The absence of a trial was, in itself, a matter noted with some frustration in the press coverage that followed the case through the remainder of the summer of 1872, coverage that returned repeatedly to the boldness of a crime committed in broad daylight within an occupied shop on a public thoroughfare without a single witness having observed either the act or the departure of whoever had committed it. Newspapers of the period described the case as one rarely paralleled in their experience, a description that reflected less any claim about the scale of the violence than about the sheer audacity of its setting and hour. The immediate aftermath of the discovery brought a period of heightened attention to Hyde Road and its surrounding streets, as residents of Hoxton absorbed the fact that a double killing had taken place within an ordinary shop during the busiest hours of an ordinary trading day. Shopkeepers in the district were reported to have taken additional precautions in the weeks following the crime, a response consistent with the unease that a crime of this kind, committed against tradespeople within their own premises, was liable to produce among others who kept similar premises nearby. This unease did not, however, translate into any new information reaching the investigating officers, and the trail available to them grew progressively colder as the weeks passed without an arrest. The Metropolitan Force maintained an interest in the case beyond the initial weeks of investigation, continuing to receive and record such information as members of the public brought forward, though none of it proved sufficient to identify a suspect. As months passed without resolution, the case gradually receded from the sustained attention of the London press, following a pattern common to unsolved crimes of the period, in which initial, intensive coverage gave way to periodic mention whenever some new development, however minor, seemed to warrant it. No such development of substance is recorded as having occurred in the years immediately following 1872. The shop at 46 Hyde Road did not, so far as the surviving record indicates, resume its former character as the Squires family business, the deaths of both women having brought the concern to its end. The fate of the stock, the fixtures and the tenancy of the premises in the aftermath of the crime is not documented in the sources available for this account, and no detail beyond the fact of the business's cessation is offered here. The wider trade in prints and pictures that had sustained the family's livelihood continued elsewhere in Hoxton and across London, conducted by other proprietors in other shops, while the particular premises at Hyde Road passed, in due course, into other hands. The case of Sarah and Christiana Squires found a place in the broader documentation of London's Victorian crime through subsequent compilations of the period's unsolved cases, works that gathered together the details of killings which had never reached trial, and set them alongside the more famous prosecutions of the era. Such accounts, drawing on the surviving newspaper record, preserved the essential facts of the case: the identities of the two women, the nature of their trade, the circumstances of the discovery, and the absence of any resolution, without adding materially to what the contemporary press had already established. The case did not generate the ballads, broadsides, or dramatic adaptations that attached themselves to some of the more notorious crimes of the period, its obscurity outside specialist archives persisting through the decades that followed. Within the local memory of Hoxton itself, the killing of the two women appears to have persisted for some years as a point of reference among residents of Hyde Road and the surrounding streets, a case recalled less for any lasting public notoriety than for the manner in which it had disturbed the ordinary rhythm of a working trade district in the middle of a summer morning. No memorial plaque or formal commemoration of the case is documented, and no legal or procedural reform is recorded as having followed directly from it, the crime remaining in the fullest sense an isolated and unresolved event within the district's history. The broader context of policing in the East End during this period was one of steady, incremental development, in which detective work of the kind attempted in the Squire's investigation depended heavily upon the willingness of neighbours, trade contacts, and members of the public to come forward with observations, in the absence of the forensic techniques that later generations of investigators would bring to bear on cases of this kind. The Hyde Road case, conducted as it was through canvassing, witness statement, and the patient elimination of known associates of the household, reflected the investigative methods available to officers of the Metropolitan Force in 1872, methods that in this instance proved insufficient to identify the person or persons responsible. A reward was offered in the weeks following the killings, a common recourse of the period when an investigation had exhausted its immediate leads without producing a suspect. Notices were posted in the vicinity of Hoxton and printed in the local press, offering payment for information leading to the identification and conviction of the person or persons responsible for the deaths of Sarah and Christiana Squires. Such notices were a standard instrument of Victorian criminal investigation, intended to draw forward any individual who might have witnessed something of relevance but had, for whatever reason, not yet come to the attention of the police. The precise sum offered in this instance is not preserved with certainty in the sources available for this account, though the practice itself is well documented as a recurring feature of unsolved cases from the period. The posting of such a reward notice would, in the ordinary course of events, have been accompanied by handbills describing the circumstances of the crime in general terms, inviting any person with knowledge of a stranger seen in the vicinity of Hyde Road on the morning of the 10th of July to come forward. These notices were typically distributed among the public houses, lodging premises, and trade establishments of the surrounding streets, on the reasoning that a crime committed in daylight in an occupied shop was one that a sufficiently attentive passer-by might, in principle, have some fragment of knowledge relevant to solving. No record survives of any information having been produced through this channel that materially advanced the investigation. The failure of the reward to produce a result was, in itself, consistent with the broader difficulty that had confronted the investigating officers from the outset, namely the absence of any witness who had observed either an intruder entering the shop or a person departing it in an agitated or hurried state during the hours in question. This absence suggested to those conducting the inquiry that whoever had committed the killings had done so and departed the premises without attracting notice on a street that was, by all accounts, in its ordinary state of daytime activity. The implication drawn at the time, though never confirmed by any subsequent development, was that the person responsible may have appeared to observers as an unremarkable visitor to the shop, someone whose presence within an ordinary trade premises would not, in itself, have seemed cause for alarm. Officers also gave consideration, in the course of their inquiries, to the physical layout of the shop itself, examining whether the counter and the arrangement of stock within the premises might have obstructed a clear view from the street of whatever had taken place inside. The wholesale trade in prints and pictures required a substantial quantity of stock to be displayed and stored within a comparatively confined space, and it was suggested at the time that the density of this stock, stacked and arranged throughout the shop, might have shielded the interior from the casual notice of anyone passing on the pavement outside. This consideration did not, however, translate into any specific finding capable of narrowing the circle of possible witnesses or suspects. The funerals of Sarah and Christiana Squires were held within the fortnight following their deaths, drawing a considerable gathering of neighbours, trade acquaintances, and residents of Hoxton to witness the burial of a mother and daughter whose deaths had so disturbed the ordinary life of the district. Accounts of the period describe a substantial crowd assembling along the route taken by the funeral procession, a common response in Victorian London to a crime that had touched a locally known family in circumstances so publicly discussed. The two coffins were reported to have been carried together, reflecting the fact that mother and daughter had died within the same hour and were being laid to rest as a single, connected loss to those who had known them. The precise burial ground in which Sarah and Christiana Squires were interred is not established with certainty in the sources available for this account, though East London parishes of the period maintained burial grounds and cemeteries sufficient to serve the needs of Hoxton and the surrounding district, and it is to one of these that the funeral procession is understood to have proceeded. The gathering of mourners was reported to have included not only family connections and immediate neighbours, but also a wider public drawn by the notoriety the case had already acquired in the days since the discovery, a pattern consistent with the manner in which Victorian funerals for victims of unresolved violent crime frequently became occasions of considerable public attention, distinct in character from an ordinary family bereavement. Trade contacts of the family, the retailers and hawkers who had purchased stock from Sarah Squires in the ordinary course of her business, were noted among those attending, a detail that reflected the standing the Hyde Road shop had maintained within its particular corner of the wholesale print trade, despite its modest scale. The closure of the shop itself, following so directly upon the deaths of the two women who had run it, marked the practical end of a business that had operated at the same premises for a period of years, though the exact length of that tenure is not established in the surviving record. In the weeks following the burial, subscriptions were reported to have been raised among residents and tradespeople of the district, a customary Victorian response to a crime of this kind, intended to supplement the official reward already posted and to demonstrate the strength of local feeling that the person responsible should be brought to account. Such subscriptions, common in cases where a locally known victim had been killed under circumstances that left the wider community uneasy, rarely produced information beyond what official channels had already gathered, and the Hyde Road case proved no exception to that pattern. The additional funds raised through this local effort do not appear, on the basis of the surviving record, to have altered the course of an investigation that had already, by the autumn of 1872, settled into the condition it would retain for the remainder of its history, that of a case fully investigated and formally unresolved. The most detailed treatment the case has since received appears in Jan Bonderson's study of London's lesser-known Victorian murders, published under the title Rivals of the Ripper, a work that gathered together a number of killings from the period that had never been resolved, and had, for the most part, faded from public memory outside specialist circles. Bonderson's account draws upon the contemporary newspaper coverage of the case, presenting the killing of Sarah and Christiana Squires alongside other unsolved crimes of the era, as an example of the kind of violence that London's police force, for all its developing methods, was not always able to bring to a conclusion. The treatment situates the case within a broader pattern of East End crime during the 1870s, without asserting any connection between the Hyde Road killings and any other case examined in the same study. Beyond this published treatment, the case survives principally in the digitised archive of Victorian London crime maintained under the address victorianlondon.org, a compilation that preserves transcriptions and summaries of period newspaper reporting on a wide range of 19th century offences, among them the killing of the two women at Hyde Road. This archive, together with walking tour material developed for visitors to London's East End interested in the district's Victorian criminal history, represents the principal channel through which the case has continued to be referenced in the years since its original investigation. No film, stage adaptation, or ballad is documented as having drawn upon the case, and it has not entered the broader cultural memory of Victorian crime in the manner of the more notorious prosecutions of the period. The case's continued presence within these specialist compilations reflects a pattern common to a great many Victorian killings that were never solved, in which the absence of a trial, a named defendant, or a resolved verdict left the case without the narrative structure that tends to sustain public interest across succeeding generations. A crime without a court proceeding to report, without a sentence to record, and without a named individual whose fate could be traced beyond the crime itself, offered later chroniclers comparatively little beyond the bare facts established by the contemporary press and the inquest record. It is on the strength of those bare facts, preserved in the newspaper archives of 1872 and transcribed in the compilations that followed, that the case of Sarah and Christiana Squires has continued to be documented into the present day, a record of two women killed within their own shop on an ordinary July morning, and of an investigation that identified no one to answer for it. The wholesale trade in prints and pictures that sustained the Squires household was a substantial branch of London commerce in the early 1870s, supplying the great number of small retailers, market stalls, and itinerant sellers who offered decorative and devotional images to a public whose homes, across every level of London society, commonly displayed such prints upon their walls. The stock that filled the shelves and counters of the Hyde Road premises would have included steel and wood engravings reproduced from popular paintings, chromolithographed scenes of a sentimental or patriotic character, portraits of the Queen and members of the royal family, and religious subjects intended for sale to households seeking an affordable devotional image for the parlour or bedroom wall. A wholesale dealer of this kind purchased such prints in bulk from printers and publishers, often at considerable discount, and sold them on in smaller quantities to the retailers and hawkers who carried them into the streets and markets of London for resale to the public at large. This structure of trade required the proprietor to maintain working relationships with a range of suppliers on one side and customers on the other, extending credit where necessary and managing the turnover of stock so that popular subjects did not sit unsold while less fashionable images accumulated. It was a trade that rewarded steady attention and a working knowledge of which images were, in a given season, likely to sell. Knowledge that a proprietor such as Sarah Squires would have built up over years of dealing. The physical stock of such a shop, densely packed with framed and unframed prints, stacked against walls and arranged upon shelves and counters, gave the interior of premises, such as 46 Hyde Road, a crowded, layered character quite different from the open floor of a grocer or a draper. Customers moving through such a shop would have done so among stacks of pictures reaching toward the ceiling in places. The light from the street window falling across glazed frames and unglazed sheets alike, the smell of paper, ink and varnish characteristic of premises given over to this particular trade. It was within this crowded, familiar setting, built up over years of ordinary commerce, that the violence of the 10th of July took place, a violence that left the same stock of prints and pictures scattered and marked in a manner altogether unlike anything the shop's ordinary trade had ever produced. The position Sarah Squires occupied as a widow conducting trade in her own name reflected a legal status recognised in English law as that of a feme sole trader, a status by which a widow, unlike a married woman whose property and contracts remained for much of this period under the legal authority of her husband, retained the right to conduct business, hold stock, extend and receive credit, and enter into trade agreements entirely in her own capacity. This status was not unusual among London's widowed tradeswomen of the period, many of whom continued businesses established by deceased husbands rather than allowing the trade connections and goodwill built up over years to lapse. It placed Sarah Squires among a recognisable, if numerically modest, category of women who maintained independent commercial standing within their own communities, answerable to suppliers and customers in their own right, rather than through the mediation of a male relative. Christiana Squires, remaining unmarried and residing with her mother, occupied a position common to a great many daughters of tradeswomen in this period, contributing her labour to the family business while the household's legal and commercial standing remained vested in her mother as proprietor. Such arrangements, in which an unmarried daughter worked alongside a widowed mother in a shop or trade concern, were a familiar feature of working and lower middle class London households, offering a daughter a measure of economic purpose and a mother a source of assistance in managing a business that a single proprietor might otherwise have found difficult to sustain alone. The precise division of labour between Sarah and Christiana Squires within the daily operation of the Hyde Road shop is not documented beyond the general fact of their shared occupation of the premises and their joint conduct of its trade. The killing of two women in these circumstances, a widowed proprietor and her working daughter, within a shop of this kind, was not without precedent in the broader record of London crime during the middle decades of the 19th century, though no specific comparable case is documented in the sources available for this account as having been drawn upon by contemporary reporters in their coverage of the Hyde Road killings. Shopkeepers, and in particular those who kept small premises with limited assistance and comparatively little protection against a determined intruder, were understood at the time to occupy a position of some vulnerability, their trade requiring them to admit any member of the public who chose to step through the door, without the means available to larger commercial establishments to screen or restrict access to their premises. This vulnerability, inherent to the nature of small retail and wholesale trade throughout London's working districts, was frequently remarked upon in the aftermath of crimes of this kind, without any suggestion that it amounted to a pattern traceable to a single individual or organised cause. The vulnerability inherent to small shopkeeping in districts such as Hoxton was compounded, in the particular case of the Hyde Road premises, by the fact that only 2 women occupied the shop during its working hours, without an assistant, apprentice or male relative present to share in its daily operation or to offer protection against an intruder who meant harm. Many trade premises of comparable size in the district employed at least one additional hand, whether a shop boy engaged to carry goods and mind the counter during slack periods, or an apprentice bound to learn the trade while assisting in its daily conduct. The Squire's household, so far as the surviving record indicates, relied upon the labour of mother and daughter alone, a circumstance that left the shop, during any hour in which both women might be occupied with stock or with a customer at the rear of the premises, without a third pair of eyes upon the street door. This absence of additional staff was not remarked upon by contemporary reporters as a fault or a want of prudence on the part of Sarah Squires, but rather as a simple fact of the household circumstances, consistent with the modest scale on which the business appears to have operated. A great many small trade premises throughout Hoxton and the wider East End were conducted on precisely this basis, by a single proprietor or a small family group, without the resources to employ additional hands beyond what the turnover of the business could reasonably support. The Hyde Road shop in this respect differed little from its neighbours, and the particular danger that its lack of additional staff exposed it to on the 10th of July 1872 was not evident until the events of that day had already taken place. In the months that followed, some shopkeepers in the immediate vicinity of Hyde Road were reported to have engaged additional assistance where their trade permitted it, a precaution taken in direct response to the killings and to the unease that persisted among tradespeople who, like Sarah and Christiana Squires, conducted business alone or with only family members present. Bells were fitted to shop doors in some premises, a mechanism by which a proprietor, working toward the rear of a shop, might be alerted to the entry of a customer, even when not directly facing the street door, a modest technological response to a vulnerability that the events of July had made newly apparent to those who traded in similar circumstances throughout the district. The bells fitted to shop doors in this manner were simple mechanisms, a small spring-mounted bell mounted above the frame, or a wire strung to a handbell placed within reach of the counter, sounding at the moment the door was pushed open and alerting whoever stood at the rear of the shop to the arrival of a visitor. Ironmongers and locksmiths within the district reported a modest increase in demand for such fittings during the months following the killings, a demand that reflected the practical, unspectacular manner in which tradespeople of the period tended to respond to a disturbance of this kind, through small adjustments to the physical arrangement of their premises rather than through any dramatic change in the conduct of their business. Some proprietors were reported to have taken to keeping their street doors latched during the quieter hours of the trading day, requiring a customer to knock or to work the latch before entering, a departure from the customary practice of leaving a shop door standing open to the street throughout the hours of business. This adjustment, while it offered a measure of additional control over who entered a given premises, carried its own cost in trade, since a latched door was understood by many prospective customers as a signal that a shop was closed, and proprietors who adopted the practice risked losing casual custom that might otherwise have stepped in from the street. The balance between this measure of caution and the ordinary need to keep a trade visibly open to passing customers was one that individual shopkeepers in Hoxton weighed according to their own circumstances in the months that followed July 1872. Trade associations connected with the print and picture dealing business, of the kind to which Sarah Squires' suppliers and customers belonged, were reported to have taken note of the killings as a matter of concern to their membership, given that the trade depended upon a network of small proprietors of precisely the kind that the Hyde Road shop represented. No formal resolution or organised response is documented as having emerged from these trade circles, and the practical adjustments made by individual shopkeepers in the district appear to have proceeded on an informal household-by-household basis rather than through any coordinated effort. The killings in this respect produced a diffuse and gradual shift in the everyday habits of a trading community, rather than any single dramatic change traceable to a particular date or decision. This diffuse and gradual response among Hoxton's tradespeople persisted through the remainder of 1872 and into the following year, as the case itself passed out of active investigation and into the status of a closed file without resolution. The officers who had conducted the original inquiries continued, for a period, to receive occasional reports from members of the public claiming knowledge of the crime, each of which was recorded and examined in turn according to the standard practice of the force, though none advanced the case beyond the position it had reached in the weeks immediately following the discovery. The file remained open in the technical sense that no statute of limitation applied to a charge of wilful murder, meaning that any credible information received at any future date might, in principle, still have led to a prosecution, but the practical likelihood of such a development diminished steadily as the years passed without new evidence. The redevelopment that eventually swept through Hoxton in the decades following the Squires' killings proceeded in stages characteristic of London's East End more broadly, beginning with the piecemeal renewal of individual shop fronts and tenancies during the later Victorian period, and accelerating into more comprehensive change under the slum clearance and housing programmes undertaken by the London County Council in the years around the turn of the 20th century. These programmes, aimed at replacing the district's older, more crowded housing stock with purpose-built dwellings, altered the physical character of streets throughout Hoxton, though the commercial frontage along thoroughfares such as Hyde Road tended to persist in altered form, even as the housing behind and above such premises was rebuilt. The district suffered further and more severe disruption during the bombing campaigns of the Second World War, when the East End of London, lying close to the docks and to industrial premises that made it a repeated target, sustained substantial damage across many of its streets. Hoxton was among the districts affected by this bombing, and it is probable, though not established with specific documentation for the exact site of the former squire's premises, that the commercial buildings along Hyde Road experienced damage or destruction consistent with the wider pattern of loss recorded across the district during this period. Whatever remained of the shopfront that Sarah and Christiana Squires had once kept would, in the ordinary course of this citywide disruption, have been substantially altered from its 1872 form well before the middle of the 20th century. Post-war reconstruction brought further change to Hoxton, as damaged and outdated premises across the district were replaced with newer building stock suited to the housing and commercial needs of a city rebuilding itself in the decades following 1945. This pattern of loss and rebuilding, repeated across countless streets throughout London's East End, meant that few individual sites connected to 19th century crimes retained any physical trace of their earlier history by the later 20th century, the Hyde Road premises among them. What survived of the case, therefore, was not any physical remnant of the shop itself, but the documentary record alone, preserved in the newspaper columns, the inquest file, and the later compilations that drew upon them. No arrest was ever made. The investigation was formally closed. The case remains open. The record remains incomplete. That is where the record of the second case ends. We turn now to the last of these three accounts, a case that unfolded in a different corner of London, in a household far removed from the one just described, and yet touched by the same unanswered question that closes every file in this archive. It concerns a woman who lived alone, in comfort, in a quiet residential square, and who was found dead one December night, with no one ever brought to account. The case of Rachel Samuel begins in Bloomsbury, London, in December of 1878. Bloomsbury by this date was one of the more settled and respectable districts of the metropolis. A network of Georgian squares and crescents, laid out in the decades following the turn of the century, built to house professional families, widows of independent means, and the comfortable edges of the London middle class. The terraces were tall and uniform, faced in stucco or plain brick, their facades broken by iron railings, area steps leading down to basement kitchens, and porticoed doorways that gave the streets an air of quiet permanence. Burton Crescent, where Rachel Samuel resided, was one such street, a curved terrace of substantial townhouses standing a short distance from Euston Road and the great railway termini that had transformed the northern edge of the district over the preceding decades. By the late 1870s, London itself had grown into the largest city in the world, its population exceeding 4 million, and its boundaries extending well beyond what had been considered the metropolis a generation earlier. The railways had reshaped Bloomsbury and its neighbouring districts, bringing traffic, commerce, and a transient population of travellers into streets that had once been almost entirely residential. Burton Crescent stood close enough to this activity to feel its presence, yet retained the character of an established residential address, home to households that kept servants, maintained regular habits, and expected, as a matter of course, the ordinary security of a settled neighbourhood. The houses of Burton Crescent were the kind occupied by widows of comfortable means, by professional men and their families, and by the small number of servants such households required. A woman living alone in one of these houses was not unusual for the period. Widowhood was common, life expectancy for men trailing that of women in many circumstances, and a widow with adequate means might reasonably choose to remain in her own establishment rather than take up residence with relatives, provided she employed servants sufficient to manage the household. Rachel Samuel was, by the description that survives of her, a widow of some means, established in her house at number 4, Burton Crescent, and known in the neighbourhood as a woman of settled and comfortable circumstances. The available record does not establish where Rachel Samuel was born, the identity of her parents, or the particulars of her early life. It does not establish the name or occupation of her late husband, nor the date of his death, nor how long she had resided at Burton Crescent before December of 1878. These details, if they were ever recorded in the newspapers or parish registers of the period, have not survived in any source accessible to this account, and the record available does not permit them to be stated with confidence. What can be said is drawn from the circumstances of the case itself, from the condition in which her household was found, and from the character of the address at which she lived. The house at Burton Crescent, as later described, contained the ordinary comforts of a woman of independent means. She was known to keep fine jewellery, wearing it, by report, within her own home. She was known to keep a substantial sum of money, in gold coin and in notes, in a place readily accessible within the house, a habit not uncommon among widows of the period who preferred to keep a portion of their resources close at hand rather than lodged entirely with a bank or solicitor. Whether this habit was widely known beyond her own household, or known only to those who had occasion to enter it, the record does not establish. It is a detail that would come to bear directly on the case that followed. A household of this kind, in a street of this character, would ordinarily have included at least one servant, engaged to manage the domestic work that a woman of Rachel Samuel's standing would not have undertaken herself. The record indicates that she had, at some point, employed a woman named Mary Donovan in this capacity. The nature of that employment, its duration, and the circumstances under which it ended or continued into December of 1878 are not established with certainty in the sources available to this account. Mary Donovan's connection to the household is confirmed only in the broadest terms as a former servant, and nothing further concerning the terms of her employment, her character, or her circumstances at the time of the crime can be stated as established fact. The immediate circumstances preceding the crime, the particulars of Rachel Samuel's final days, her visitors, her correspondence, or any dispute or disturbance that might have preceded what followed, are not documented in any source available to this account. No newspaper report or archival record has been identified that describes her movements in the days before December of 1878, nor any incident that might be read, with hindsight, as a warning of what was to come. The household, so far as the record shows, proceeded as it always had, a widow living in her own establishment, attended by whatever domestic help she then retained, in a street regarded as a settled and unremarkable address. December in London during this period brought early darkness, cold weather, and the particular quiet that settled over residential squares once the shops had closed and the ordinary traffic of the day had subsided. Street lighting in a district such as Bloomsbury would have consisted of gas lamps at intervals along the pavement, sufficient to mark the general shape of the street, but leaving substantial stretches in shadow, particularly around area steps and the recessed doorways common to the terraced housing of the period. A house standing alone, its occupant unaccompanied by family, would have depended for its security on locked doors, drawn curtains, and whatever vigilance its servants maintained, rather than on any presence beyond its own walls. It was into this setting, a comfortable house in a respectable crescent, occupied by a widow living without the protection of a resident husband or grown children that the events of December 1878 intruded. The exact day on which the crime occurred is not established in the sources available to this account, and this record does not assign a specific date beyond the month and year in which it is known to have taken place. What is established through the crime writing of the period and its subsequent compilation into records of unsolved metropolitan murders is that Rachel Samuel was killed within her own house, in her kitchen, during the hours of night. The circumstances of a woman living alone in a house of some value, situated on a street where neighbouring households kept their own hours and their own concerns, meant that a crime committed after nightfall might proceed for some time without interruption or discovery. There is no indication in the available record of any outcry heard by neighbours, of any disturbance reported to the police before the crime was discovered, or of any witness who observed unusual activity about the house that night. The absence of such testimony in the record does not establish that none existed. It establishes only that none has survived in the sources available to this account, and the gap is noted rather than filled. The attack itself, as described in the period crime writing from which this case is chiefly drawn, was one of considerable violence. Rachel Samuel was beaten, and the injuries she sustained proved fatal. The available sources do not provide the clinical detail that a modern post-mortem report might contain, no description of the number or nature of individual wounds, no named physician credited with the examination, and no surviving inquest transcript setting out medical testimony in full. What the record does establish with reasonable confidence is that the cause of death was the result of a violent physical assault, that it occurred within the house, and that whoever committed the act did not remain to be discovered at the scene. What has been preserved with unusual clarity, and what marks this case apart from many others of its kind, concerns not what was taken from the house, but what was left behind. Rachel Samuel was, by the account that survives, found still wearing jewellery of evident value. The sum of money she was known to keep within reach, in gold and in notes, was later reported to have been left where it lay, undisturbed. This detail is drawn from period crime writing on London's more notorious residential streets, compiled some years after the event, and it stands somewhat apart from an alternative account, occasionally repeated, that describes certain items, a wedding ring, a quantity of coin, a pair of boots, as having been removed from the premises. These two versions of events cannot both be stated as established fact, and this account does not attempt to resolve the discrepancy by asserting one over the other with false confidence. The more substantially sourced version, drawn from the period compilations of London's unsolved crimes, describes a house in which valuables of considerable worth were left entirely untouched, a detail that was remarked upon at the time as deepening rather than resolving the mystery of what had occurred. If a contrary account exists describing specific items as missing, the record available to this account does not establish it with the same degree of confidence, and it is presented here only as a secondary and unverified tradition, not as settled fact. What can be stated is that the presence of undisturbed valuables, whether entire or partial, meant that robbery could not be assumed as a straightforward explanation for what had taken place, and that the household itself offered few immediate answers as to motive. The discovery of Rachel Samuel's body, the identity of who first came upon her, and the exact hour at which the alarm was raised are not established in the sources available to this account. A household of the kind she maintained would ordinarily have been entered in the course of the following morning, whether by a servant arriving to begin the day's work, by a tradesman calling at the door, or by some other member of the household or neighbourhood whose ordinary business brought them to the house. Whoever it was that first found her, and under what precise circumstances, has not survived in any record accessible to this account, and this account does not assign a name or a narrative to that moment where the sources are silent. What is certain is that the discovery, whenever and by whomever it was made, brought the matter at once to the attention of the Metropolitan Police, and that a case of this nature, a woman of means found dead by violence within her own house, in a respectable London square, would have commanded immediate and serious attention from the district's constabulary. The investigation that followed proceeded according to the standard procedures of the period, procedures that had by the late 1870s become well established across the metropolis for the handling of a sudden and violent death. Officers attached to the local division would have been dispatched to Burton Crescent within a short time of the alarm being raised, their first task the securing of the house and the preservation of whatever could be observed of the scene before it was disturbed further by the ordinary traffic of a household in crisis. A sergeant or inspector attached to the division would customarily have taken charge of the initial inquiry, directing constables to examine the doors and windows of the house for signs of forced entry, to note the condition of the rooms, and to begin the process of establishing who had last seen Rachel Samuel alive. The names of the specific officers who conducted this work at Burton Crescent are not established in the sources available to this account, and this record does not assign names where none survive. A central question for any officer examining the scene would have been the means by which the assailant had gained entry to the house. A property of this kind, occupied by a woman living alone, would ordinarily have been secured each night, its street door bolted, its area gate and basement entrance checked before the household retired. Whether the house showed evidence of forced entry, a broken window, a forced lock, a door left unsecured, is not established in the sources available to this account. The absence of such a detail in the surviving record leaves open the possibility, though it cannot be stated as confirmed fact, that whoever entered the house that night did so by means that did not require force, whether through a door left unbolted, a window left unlatched, or some other circumstance not recorded. The investigation would necessarily have turned to the question of who had access to the house and knowledge of its contents. A servant, current or former, occupied a particular position in such an inquiry, possessing knowledge that an outside intruder would not ordinarily have had familiarity with the household's routine, its hours, and in this case, the location of valuables kept within reach rather than lodged with a bank. It was in the course of this line of inquiry that attention came to rest upon Mary Donovan, described in the record as a former servant of the household. The particulars of how the police came to regard her as a person of interest, what evidence or statement first directed their attention toward her, are not established in the sources available to this account, and this record does not construct a chain of reasoning where the surviving material provides none. What can be stated is that Mary Donovan was in due course taken into custody in connection with the death of Rachel Samuel. An arrest of this kind, in a case of this gravity, would have followed the ordinary procedure of the period. The suspect brought before a sitting magistrate, informed of the charge, and either released or remanded pending further evidence. The specific date of her arrest, the magistrate before whom she first appeared, and the precise terms in which the charge was framed are not established in the sources available to this account. This record does not attribute to her any statement, confession, or motive beyond the bare fact of her prior service in the household, and it does not construct an account of ill-feeling, dismissal, or dispute between her and Rachel Samuel where none is documented. While the investigation proceeded, the body of Rachel Samuel would have been examined in accordance with the standard practice of the period, a physician attached to the district, or called specifically for the purpose, conducting an examination sufficient to establish the cause of death and to inform the coroner ahead of the inquest. The name of the examining physician is not established in the sources available to this account. What is established with reasonable confidence is that the examination confirmed death by violence, consistent with a severe and rapidly fatal assault, and that no finding arising from that examination is recorded as having pointed toward a specific instrument, method, or assailant beyond what has already been described. A coroner's inquest would, as a matter of routine, have been convened within a short period following the discovery of the body, most likely at a public house or parish hall in the vicinity of Burton Crescent, this being the customary venue for such proceedings in a district that did not maintain a purpose-built coroner's court. A jury drawn from local residents would have been sworn, the body formally viewed as required by the procedure of the period, and evidence taken from those able to speak to the discovery of the body, the condition of the house, and the findings of the medical examination. The specific coroner presiding, the composition of the jury, and the verdict returned are not established in the sources available to this account. What the broader record does establish, through its consistent classification of the case as unsolved, is that whatever verdict the inquest returned, it did not result in a settled determination of responsibility that satisfied the requirements of a subsequent prosecution. The case against Mary Donovan, whatever evidence had supported her arrest, did not proceed to a conviction. The available record indicates that she was released, the charge against her not sustained for want of sufficient evidence to bring the matter to trial or to secure a verdict against her. This outcome, an arrest followed by release without conviction, was not unusual in cases of this kind during the period, particularly where an investigation rested on circumstantial association rather than direct evidence connecting a suspect to the act itself. No further suspect is recorded in the sources available to this account as having been identified, arrested, or charged in connection with the death of Rachel Samuel following Mary Donovan's release. The investigation, so far as the surviving record permits it to be traced, appears to have proceeded no further after this point. No subsequent arrest, no renewed inquiry, and no later development altering the status of the case has been identified in the sources available to this account. The file, in the terms used by the period's own crime writers, was left open, its central question, the identity of whoever entered Rachel Samuel's house that December night, never conclusively answered. Burton Crescent itself carried, even before December of 1878, something of a reputation among those who wrote of London's more troubled addresses, a street whose respectable facade had already been associated, in the years preceding this case, with more than one incident that drew the attention of the police and the newspapers. This reputation was not unique to Burton Crescent among the streets of Bloomsbury and its surrounding districts, where the outward uniformity of the Georgian terrace could conceal, behind any one of 100 identical doorways, a household in genuine distress or genuine danger, indistinguishable from its neighbours until some crisis brought it briefly into public notice. The death of Rachel Samuel added a further entry to that reputation, one that period crime writers would return to in their surveys of the capital's unresolved cases, grouping it alongside other crimes committed within the same short stretch of streets during the closing decades of the century. The practice of grouping such cases together, several unresolved deaths occurring within a small radius of streets over a span of years, was itself a recognisable feature of how the crime writing of the period and its later retrospective compilations approached London's residential districts. A single unsolved death might pass into obscurity within a generation, noted only in the local newspaper of the week it occurred. A cluster of such deaths, sharing a street or a small district in common, tended to be remembered longer, cited by later writers surveying the capital's unsolved crimes as evidence of a particular address's misfortune, even where the individual cases bore little relation to one another beyond their shared postal geography and their shared failure to reach a resolved verdict. Rachel Samuel's death entered this category of memory, preserved less as an individually famous case than as one entry within a larger accounting of streets whose respectable exteriors had, on more than one occasion, given onto scenes the police were never able to fully explain. The household at Burton Crescent, once the investigation had run its course and Mary Donovan had been released without charge, would in the ordinary course of events have passed to whatever heirs or executors were entitled under Rachel Samuel's will, or, in the absence of a will, under the ordinary rules governing intestate succession. The disposition of the house itself, whether it was sold, let to new tenants, or retained by family connections not otherwise documented in this account, is not established in the sources available to this record. Houses of this kind rarely stood empty for long in a district as sought after as Bloomsbury, and it is reasonable to note, without asserting a specific outcome, that a property of this value and situation would ordinarily have found a new occupant within a relatively short interval, the street itself giving no outward sign to a new resident of what had occurred within its walls only months or years before. The particulars of Mary Donovan's life following her release are not established in the sources available to this account. No subsequent appearance in the newspapers, no further connection to the case, and no later statement attributed to her regarding the events of December 1878 has been identified. This absence is noted here as a gap in the record rather than filled with supposition. A woman released from custody without charge in a case of this kind, in the London of the late 1870s, might have continued in domestic service, sought employment in another household or another district entirely, or left London altogether, and the surviving record does not permit any of these possibilities to be stated as the established course of her life thereafter. The vulnerability that shaped the circumstances of Rachel Samuel's death was, in itself, a condition shared by a considerable number of women across the London of this period. Widowhood, combined with a degree of independent means sufficient to maintain a household without resort to relatives, placed a woman in a position that was, on the one hand, a mark of some social standing, and on the other, a household without the resident protection that a husband, adult sons, or an extended family living under one roof might have provided. Such women relied of necessity on the servants they employed and on the general orderliness of the street in which they lived, rather than on any more direct form of protection. The arrangement worked well enough in the great majority of cases across the great majority of nights in Bloomsbury and districts like it. It failed on this occasion in a manner that neither the household's own precautions nor the vigilance of its neighbours had been sufficient to prevent. The case of Rachel Samuel survives today chiefly within two kinds of source, each serving a different purpose in the preservation of the record. The first is the tradition of London crime writing concerned specifically with the capital streets of ill repute, compilations produced over the decades following the case that gathered together the unsolved and half-remembered deaths associated with particular addresses, Burton Crescent among them, presenting them as a connected sequence of local history rather than as isolated criminal cases. The second is the broader cataloguing of unresolved British homicides undertaken in more recent reference compilations, which list Rachel Samuel's death alongside a great many others from the same century, each entry brief, each confirming principally the fact that no one was ever convicted of the crime. Neither tradition has produced a book-length study devoted to this case alone, and no dramatisation, memorial, or work of fiction drawing directly on Rachel Samuel's death has been identified in the sources available to this account. The case persists, where it persists at all, as one entry among many, its details preserved in outline rather than in the fuller documentary record that survives for more widely studied crimes of the period. What the surviving record does preserve, and preserves with reasonable consistency across the sources that mention the case at all, is the particular circumstance that gave Rachel Samuel's death its distinct character among the unsolved crimes of the district, the presence within the house, undisturbed, of valuables that a robbery would ordinarily have been expected to take. Jewellery worn upon her person remained in place. A sum of money kept within the house, in gold and in paper notes, remained where it had been kept. This detail, repeated across the crime, writing that treats of Burton Crescent, was understood at the time, and has continued to be understood by those who have written of the case since, as the central puzzle at the heart of an already puzzling crime. A death by violence within a locked household at night, without forced entry established, and without the ordinary motive of theft to explain it, left investigators of the period, and has left writers of every period since, without a settled account of what the assailant had actually sought in entering the house at all. The absence of an established motive did not prevent the crime writing of the period from offering informal speculation, as such writing often did in cases where the official record remained silent. Some accounts have suggested that the assailant may have been disturbed before completing whatever purpose had brought them into the house, leaving the valuables untouched not by intention, but by interruption. Others have suggested that robbery was never the object at all, and that some other grievance, undocumented and unrecoverable, lay behind the attack. Neither explanation is established by any surviving evidence, and this account does not adopt one over the other. Both are preserved here only as the kind of informal reasoning that has attached itself to the case over the decades since, offered by writers working, as this account does, from an incomplete record and reaching, as this account does not, for a resolution the evidence itself does not supply. The street on which Rachel Samuel died continued, in the years that followed, to bear the name Burton Crescent, and continued to be occupied by households of the kind she had represented, widows, professional families, and the servants who attended them, largely undisturbed by the memory of what had occurred at number 4. The gradual association of the street with a sequence of notorious and unresolved incidents, of which this was one among several, would in time contribute to a change in the address itself, though the particulars of that later change belong to a period beyond the scope of what this case can establish, and this account does not dwell upon it. What remained constant through the years immediately following December 1878 was the case file itself, held by the Metropolitan Police as an open and unresolved matter, its central question no closer to an answer with each passing year than it had been on the morning the body was discovered. The crime once reported would have appeared within the daily press of the capital in the manner customary for a case of this seriousness, a paragraph or column in the London morning papers, describing the discovery, the location, and such particulars of the investigation as the police were prepared to make public at that early stage. Newspapers of the period covering a case of this kind typically drew their information directly from statements made at the police court when a suspect was brought before a magistrate, supplementing this with whatever detail could be gathered from neighbours or tradesmen willing to speak to a reporter standing outside the house. The exact newspapers that carried notice of Rachel Samuel's death and the specific wording of their reports have not survived in any source accessible to this account, though the case's continued presence in the later compilations of London crime writing indicates that it received notice sufficient to be remembered, if only in outline, by writers working decades afterward. A death of this kind, in a street of settled and respectable character, tended to produce a particular unease among households of similar situation in the immediate vicinity. Women living alone in the neighbouring terraces, many of them widows of comparable means and comparable circumstance to Rachel Samuel herself, would have had reason, in the weeks following the discovery, to examine their own household arrangements with renewed attention, the security of their doors and windows, the reliability of the servants they employed, and the adequacy of whatever precautions had previously seemed sufficient. This kind of anxiety rarely found its way into the official record of a case, being a matter of private conduct rather than public testimony, and no specific account of such reaction among Rachel Samuel's neighbours has survived in the sources available to this account. It is noted here only as the kind of ordinary consequence that a crime of this nature, in a street of this character, would reasonably have produced among households living under comparable circumstances. The management of an unsolved case of this kind, once the initial period of active investigation had passed without result, followed the ordinary administrative practice of the Metropolitan Police during the final decades of the 19th century. A file would have been maintained recording the statements taken, the medical findings, the inquest verdict, and the outcome of Mary Donovan's arrest and release, held against the possibility that some future development, a confession, a piece of evidence recovered by chance, a statement volunteered by a witness whose conscience had changed with the passing of years, might yet bring the matter to a resolution. Such developments, in the great majority of cases left open in this manner, did not arrive. The file for Rachel Samuel's death appears, on the evidence of its continued classification, as unsolved across every later compilation that mentions it, to have remained exactly where the investigation left it, without the addition of any further evidence sufficient to reopen the case in any substantive way. The particular difficulty faced by the officers who had conducted the original inquiry, the absence of forced entry, the absence of an established motive, and the release of the one suspect who had been identified, was not unique to this case among the unsolved metropolitan murders of the period. Investigations of this kind depended heavily upon the willingness of witnesses to come forward, upon the presence of physical evidence sufficient to connect a specific individual to the scene, and upon the kind of fortunate circumstance, an overheard remark, a pawned item later identified, a change in a suspect's behaviour noticed by someone close to them, that in other cases had turned an otherwise stalled inquiry toward a resolution. None of these circumstances arose in the case of Rachel Samuel, so far as the surviving record indicates, and the investigation accordingly settled, over the months and years following December 1878, into the condition in which it has remained ever since, a case formally opened and never formally closed by any verdict of guilt. The household goods, the furniture, the ordinary contents of a comfortable widow's establishment would in time have been dispersed according to the terms of whatever will or administration governed her estate, a process handled through the ordinary channels of probate rather than through any aspect of the criminal investigation itself. The particular fate of the jewellery she had been wearing, and the sum of money left undisturbed within the house, following the conclusion of the inquest and the release of the one suspect taken into custody, is not established in the sources available to this account. It is reasonable to assume, though not established as fact, that such items would have been returned to her estate once the police had no further use for them as evidence, but no specific record of that transfer has survived in the sources consulted for this account. The house itself, standing among its identical neighbours along the curve of Burton Crescent, retained no outward mark of what had taken place within it. A new occupant, taking possession of the property in the months or years that followed, would have found nothing in its rooms to distinguish it from any other house along the terrace. The kitchen where the crime is understood to have occurred returning, in the ordinary course of domestic life, to its ordinary function, a place of daily work rather than a scene preserved in any formal sense. This was the customary fate of such houses across London, their interiors given over entirely to the needs of whichever family or individual next took up residence, the memory of what had occurred within them surviving, if it survived at all, only in the private recollection of those who had known the address at the time, and in the pages of whichever writers later chose to record it. The house at number 4, like its neighbours along the Crescent, would have followed the standard arrangement of a London terraced townhouse of its era, 4 or 5 stories including the basement, a single width plan with rooms arranged front and back on each floor, connected by a staircase running the full height of the building. The kitchen in a house of this design occupied the basement level, reached from the street by a flight of area steps descending below the level of the pavement to a service door, distinct from the main entrance above, which was reserved for the household's own use, and for the passage of coal, provisions, and the ordinary traffic of domestic supply. This arrangement, standard across the terraces of Bloomsbury and the districts built in a similar period, placed the kitchen at the point in the house most directly accessible from the street, separated from the pavement by nothing more than a set of railings and a flight of steps, and secured in the ordinary course of a night by whatever bolt or lock had been fastened on the area door before the household retired. This service entrance represented, in houses of this design generally, a point of the building considerably less guarded than the main door above, which faced the street directly and was visible to any passer-by or constable on the beat. The area steps, by contrast, descended into a recess below street level, often screened from casual view by the railings themselves, and were used in the ordinary course of the day by tradesmen making deliveries, by the servants of the household going about their errands, and by anyone else whose business brought them to the rear or lower portions of the house, rather than to its principal entrance. Whether the door at the foot of these steps was secured on the night in question, and whether it had been the means by which whoever entered the house that December gained access to it, is not established in the sources available to this account. The architecture of the house itself is described here only to indicate the kind of point of entry that a house of this design would have presented, not to assert that this particular door was the one used. A household of the size and standing of Rachel Samuel's would ordinarily have engaged its servants through one of the registry offices that had, by the 1870s, become the customary means by which domestic employment was arranged across London. A woman seeking a position as a general servant or cook would register her name, her previous experience, and, where she had it, a written character from her last employer at one of these offices, which would in turn recommend suitable candidates to households seeking to fill a vacancy. A character of this kind, a brief written statement from a previous employer attesting to a servant's honesty, competence and conduct, carried considerable weight in the hiring of domestic staff, and a servant who left a position without one, whether through dismissal or through some falling out with her employer, could find her prospects for further engagement substantially diminished. Whether Mary Donovan had been engaged through such a registry, what character she had presented upon entering Rachel Samuel's service, and under what circumstances her employment in the household came to an end, are none of them established in the sources available to this account, and this record does not supply an explanation for the end of her service, where the surviving material offers none. The relationship between a household and a former servant, once that servant's employment had ended, was not always a clean or complete severance in the London of this period. A former servant might return to a household on an errand, might be known still to tradesmen who served the street, and might retain, from her time in service, a familiarity with the household's routine, its hours, and the habits of its occupant that did not simply vanish upon her departure. It was precisely this kind of residual familiarity, rather than any specific evidence of continued contact between Mary Donovan and Rachel Samuel following the end of her employment, that appears to have directed the attention of the investigating officers toward her once the crime had been discovered. A household robbed of nothing, its owner killed within a room she would have had no particular reason to fear, presented investigators with a puzzle that pointed, in the absence of any sign of a stranger's forced entry, towards someone who required no explanation for familiarity with the house at all. December itself carried particular significance for a household of this kind, the closing weeks of the year being, in households across the social range that could afford to observe it, a season of heightened domestic activity. Tradesmen's bills fell due, servants customarily received their Christmas gratuities in addition to their regular wages, and households of comfortable means often kept a larger sum of ready money on hand during these weeks than at other points in the year to meet the additional expenses the season brought, gifts, extra provisions, the settling of accounts before the year's end. This seasonal pattern, common across households of Rachel Samuel's situation, offers a plausible context for the presence of a substantial sum in gold and notes within her house at the time of her death, without requiring any unusual or specific explanation beyond the ordinary domestic economy of the season. It does not, however, establish why that sum remained untouched by whoever entered the house, a question the surviving record leaves as unresolved as every other aspect of the case's central puzzle. The coroner's inquest into Rachel Samuel's death would have followed the procedure prescribed for such proceedings throughout England during this period. A jury of not fewer than 12, nor more than 23 men, drawn from the parish or district in which the death occurred, sworn to inquire into the cause and circumstances of death, and empowered to return a verdict binding, in the absence of a subsequent criminal trial, as the formal legal record of how the deceased had come to die. The jury would, as a matter of established practice, have been taken to view the body before evidence was heard, this viewing considered a necessary part of their qualification to render a verdict, however brief and formal the viewing itself might have been. Testimony would then have been taken in turn, beginning ordinarily with whoever had discovered the body, followed by the examining physician, and by such other witnesses as the coroner considered relevant to establishing the circumstances of death, before the jury retired to consider its verdict. The verdict a coroner's jury might return in a case of this kind ranged across a defined set of possibilities established by law: willful murder against a named person if the evidence clearly supported it, willful murder against a person or persons unknown if the evidence established the fact of murder without identifying a perpetrator, or an open verdict if the jury felt the evidence did not permit even the cause of death to be stated with full confidence. The specific verdict returned in Rachel Samuel's case is not established in the sources available to this account, though the case's subsequent and consistent treatment across every later compilation as an unsolved murder indicates, at minimum, that no verdict was returned identifying a specific individual as responsible, and that the matter passed from the coroner's proceedings into the hands of the police for further investigation, rather than toward any immediate prosecution. A suspect taken into custody in a case of this seriousness would not, under the procedure then observed in the Metropolitan Police courts, have been brought immediately to trial. She would first have appeared before a sitting magistrate at the police court serving the district in which the crime had occurred, a preliminary proceeding distinct from any trial, its purpose being to determine whether sufficient evidence existed to justify committing the accused for trial at the Central Criminal Court, commonly known as the Old Bailey, or at the Assizes, should the case have proceeded to that stage. At this initial hearing, the police would have presented such evidence as they then possessed, and the magistrate, having heard it, could either discharge the accused for want of sufficient grounds, or remand her into custody for a period while further evidence was gathered. This remand renewable at subsequent hearings held at intervals of a week or more, according to the needs of the ongoing investigation. Mary Donovan, held under this procedure, would in the ordinary course have been committed to a house of detention to await whichever of these outcomes the continuing investigation ultimately produced, a period of custody that could extend across several weeks, depending on how actively the police pursued the evidence they required. Each remand hearing would have required her to be brought again before the magistrate, the police reporting on the progress of their inquiries, and the magistrate deciding afresh whether the case against her had strengthened sufficiently to justify committal, or whether it had failed to develop and ought therefore to be brought to a close. The specific number of such hearings in Mary Donovan's case, and the length of time she remained in custody before her eventual discharge, are not established in the sources available to this account. The standard a magistrate was required to apply at this preliminary stage was not the same standard a jury would later have applied at a full trial. Committal for trial required only that the evidence presented disclose what was termed a prima facie case, sufficient, if unanswered, to raise a proper question for a jury to decide, rather than proof beyond reasonable doubt, which remained the standard reserved for the trial itself. That the case against Mary Donovan did not proceed even to this lower threshold indicates that whatever evidence the police had gathered in connecting her to the crime fell short of establishing even a prima facie case, a circumstantial association with the household perhaps, or a suspicion arising from her former position within it, but nothing that rose, in the magistrate's judgment, to the level required to place the matter before a jury at all. Her eventual discharge would have been recorded in the ordinary minutes of the police court, a brief formal entry noting that the prisoner had been brought up, that the evidence had been heard, and that she had been discharged, the charge against her withdrawn or dismissed for want of sufficient evidence to proceed further. Such an outcome, while it closed the immediate legal proceeding against her, did not carry with it any formal finding of innocence in the manner a full acquittal following trial would have done. It represented rather an acknowledgement that the investigation had not, at that point, produced evidence adequate to justify placing her before a jury, leaving the broader question of who had been responsible for Rachel Samuel's death exactly where it had stood before her arrest, unresolved, and so far as the surviving record indicates, never subsequently advanced by any further arrest or any further evidence brought against any other individual. The discharge of the one suspect who had been identified marked, in practical terms, the effective conclusion of the active investigation into Rachel Samuel's death, though the file itself, in keeping with the standard practice of the period, would have remained formally open rather than closed outright, available for reconsideration should new evidence ever come to light. No such evidence, so far as the sources available to this account indicate, was ever subsequently produced. The case passed, in the years that followed, from a matter of active police concern into the category the Metropolitan Police reserved for its unresolved and long-dormant files, revisited, if at all, only in the context of some later and unrelated inquiry that might, by chance, touch upon the same address or the same circumstances, rather than through any sustained effort directed specifically at Rachel Samuel's own case. The formal record of Rachel Samuel's case, once the investigation had settled into its unresolved state, would have been preserved among the papers of the Metropolitan Police, in the manner customary for cases of this kind during the period, entered into the register maintained by the relevant division, assigned whatever reference number the department's system of record-keeping required, and filed alongside the statements, the medical report, and the notes of the officers who had conducted the inquiry. Such files were not, as a rule, destroyed once an investigation had stalled. They were retained indefinitely, available for consultation should some future circumstance, a confession offered years later, a chance discovery, an inquiry into an entirely separate matter that happened to touch upon the same address, bring the case back into active consideration. It was from files of precisely this kind, retained across the decades following their creation, that later writers compiling accounts of London's unsolved crimes were able to draw the details that have preserved Rachel Samuel's case in outline, however incomplete, to the present day. The compilers of the period crime writing from which this account chiefly draws its record of the case were not, in the main, trained historians working from the original police files themselves, but writers assembling their accounts from newspaper reports, from the published proceedings of police courts and inquests where these had been recorded, and from the accumulated local memory of the districts they described, streets whose residents, tradesmen, and long-serving parish officials retained, across the years, an informal recollection of the crimes that had marked their neighbourhood. This method of compilation, drawing on public record and local memory rather than on the closed files of the police themselves, accounts for the particular character of what survives concerning Rachel Samuel's death, a case remembered in its broad outline and its central, striking detail, the valuables left untouched within a house where a woman had been beaten to death, but thin in precisely those particulars, the name of the examining physician, the wording of the inquest verdict, the date of Mary Donovan's discharge, that would have been recorded in the official file but were never carried forward into the public compilations that alone have preserved the case for later readers. This pattern, a case remembered in outline while its procedural particulars are lost, was not unique to Rachel Samuel's death among the unsolved crimes of Victorian London. The volume of criminal business handled by the Metropolitan Police across a city of more than 4 million residents ensured that only a small proportion of cases, generally those that were solved, prosecuted, and reported in the fuller detail a trial's public proceedings required, survived in a documentary record rich enough to support a full modern historical account. Cases that ended, as Rachel Samuel's did, in a discharge rather than a trial, generated correspondingly less public record at the time, the police court's own coverage of a discharge hearing being ordinarily far briefer than its coverage of a full committal or trial, and the newspapers accordingly having far less to report once the one identified suspect had been released without charge. The relative thinness of Rachel Samuel's surviving record is, in this sense, itself a consequence of the case's central fact, that it was never solved, and that the legal process which might otherwise have generated a fuller documentary trail never advanced beyond its earlier stages. The case of Rachel Samuel was the last of these three examined here. The investigation was formally closed in due course. No conviction followed. The case remains open in the historical record,